Welcome to AI Rounds, your weekly dose of AI in medicine and education.
We are your hosts, Dr. Nuria Negrão
and Dr. Morgan Leaf. Each week, we'll bring you a quick dive into the latest in artificial intelligence and how it's transforming healthcare, medical education, and medical communications.
From the tools changing how we teach, learn, and write, to breakthroughs shaping patient care. If it's new, exciting, or just plain useful, we're talking about it.
In just 10 to 15 minutes, we'll get you up to speed and maybe even spark your next big idea.
Let's make the rounds.
Hi, Nuria.
Hi, Morgan. How are you?
I'm good. How are you today?
Good. Just came back from a million conferences, and I'm so happy that I'm back home and I can rest for the rest of the year, basically.
You sure did have a lot of conferences there. I was glad I got to see you in Phoenix at AMWA.
Oh, that was so nice. Yes.
Yeah.
Yeah, we'll talk more about AMWA on our next episode, but today we're going to talk about a little bit of the intersection between AI and the law and some aspects that are becoming clear. Obviously, because this is such a new area, things are not very, very clear yet, but some things are becoming a little bit more clear.
And Nuria, we should probably start off by saying we're not lawyers, huh?
No, this is not legal advice. We are not lawyers. We're also not your lawyers, and this is not legal advice.
So we love talking about this. We love learning about it. The whole world is learning about this together. But take everything we say with a grain of salt. Do your own research. Talk to your own lawyer if these topics apply to you.
Yes, 100%. Yeah. And what we're talking about here today is in some of these conferences that I went to, there were a few sessions that were given by lawyers who are working in the field. And this is basically so I'll summarize more or less what they said, and then we'll give our perspective of what we think that means for us as medical writers, as people in continuing education, etc.
So a lot of this has to do with copyright, right, Nuria?
Yes, 100%. I think copyright law, the way it's written, is everything that is produced by a human has copyright inherently, right? It is a law that was created at the time of the beginning of the U.S. and it was to foster invention, right? So if you give copyright to everything that a human being creates, then that person feels safe sharing it with everyone else. Because they have this legal protection. So everyone else cannot steal it from them, but they can elaborate on it. They can make the next step. So both patent law and copyright law are key to foster innovation.
So what happens when AI comes into the picture? Who owns the copyright of products that are created by AI?
Yeah, so the answer to that is complicated, but in the key in the copyright law is that it has to be made by humans. So technically, anything that is not made by humans is not copyrightable, does not have copyright. There was a famous story a few years ago of a photographer that left his camera and then some sort of monkey went and took a selfie of himself. And then the photographer was like, no, I have copyright to this picture. The picture came out, and then other magazines and other places started publishing it without paying the original photographer. And then it went to court, and the court said, no, you did not take the picture. The monkey took the picture. So the picture the picture cannot be copyrighted because it wasn't created by a human.
So the monkey had no rights here, huh?
The monkey had no rights. The photographer had no rights. No one had rights. It was a free-for-all. Basically, this picture can be used everywhere because it wasn't made by a human. So that is that gives you an idea of where did the court stand to begin with on this question of, are things created by AI copyrightable or not? And the beginning is no. But now they have come up with a little bit more guidance. So now they say that if there has been significant human transformation of the product created by AI, it may be copyrightable. So they also don't say what significant is, and they don't say definitively these are the cases where it's copyrightable.
So we've seen some court cases coming through about this, right? New York Times and OpenAI is probably one of the more publicized ones. Have these court cases given us, is this what gave us the clarity about something may be copyrighted? Has anything come of these court cases yet?
So the New York Times and OpenAI court case is another part of copyright. It is the question of did OpenAI violate copyright when it trained its model on New York Times articles.
Mm-hmm.
So that's a different is using everything that is on the internet. What's it called? Fair use
Yeah.
of what is on the internet, or is it a violation of copyright? The question is, so what is fair use? Fair use is if you you read a bunch of New York Times articles and then you transform and you write your own stuff, and you can even refer, like you can put a small quote or something like that. That is fair use. But if you reproduce what the New York Times did, then it's not, and it's a violation of copyright. So that's one question. But there have been other court cases looking specifically at the results, at things that people created with AI, and the courts were trying to decide can this get copyright or not. And what we have seen from these court cases is, and in images it's easier to explain. So if you just prompt an image generator and it creates an image, it's not copyrightable. If you start and you do the main drawing and then you upload that and you ask the image generator to transform that main drawing, then it's a little bit more tricky. And what some courts have decided is that the elements that you drew yourself are copyrightable, but the elements that the AI produced are not, right? So if it was a black and white drawing and now it's colored, all the colors, all of that is not copyrightable, but the key ingredients that you drew are copyrightable. And I think that this is like bringing it back to medical writing. This is a little bit tricky with medical writing or with writing in general, right? Because what we're saying is that if the AI writes it, then it's not copyrightable, unless you then go and significantly change it. But what does significantly change in writing? So I don't know if you write all the plot and you develop the characters first and then it just generates, then the plot maybe is copyrightable, but the actual sentence structure is not. Or if you have AI generate the plot and all the characters, but then you make it sound pretty, then the plot is not copyrightable, but the way you wrote it is copyrightable. So how do you think that applies to medical writing?
Oh my gosh, I was going to ask you that question. Well, I'll tell you one thing. I think that the chances of what we do in medical writing going to court about this are pretty low, right? Let me rephrase that. What you and I do in CME writing, I think, is low. I think, though, with journal articles, we could definitely start to see some issues with this, both ethical and legal. Just on the AMWA Engage discussion board the other day, somebody was posting about they received peer-reviewed feedback on a journal article, and it had been generated by AI. So there was a question of whether this peer review even was done by human eyes or seen by human eyes, right? And that's a real problem in the scientific publication community. So I think for us as writers, I think we'll get into this a little bit more in our next episode when we debrief about AMWA. But we had a great discussion in one of the sessions about how much our clients, if we are freelancers, are able to dictate how we do our work, right? Legally, they're not. Legally, as independent contractors, our clients cannot dictate how we do our work. However, sometimes they do have requests that we don't use AI. And if AI-produced products are going to have copyright difficulties, are you then putting your client in an unfortunate position if you use AI in your work? And I kind of think the answer goes back to what we've been saying all along about how to use AI. None of us, as medical or scientific writers, should be using it to generate a first draft of content, right? Or a final draft or whatever it is. It's a tool to help you with your writing, to perform particular tasks, to do research, to help make agendas and other types of tasks that we do. But it feels risky at this point to use it to entirely generate content. And I feel like we should stay away from that. What do you think, Nuria?
Yeah, I think the same thing. Like we need to be very careful about this question. But I think even like from a bigger picture point of view is I think companies need to have like a little bit of a strategic conversation internally about what they want to copyright or not. And that includes us as medical writers, for example. So, like, if I want to create a logo for my business, maybe I do not want AI to create the logo for my business because that logo will not be copyrightable. Imagine my business takes off and it becomes a multi-million-dollar company. Yes, this is what we want. The fact that I created my logo with AI means that you, Morgan, can go and take my logo and do business and pretend to be me, and that there's nothing I can do about it. So if it is critical things like that, like your logo, like your image, that because of a future business needs, you do not want it to be copyrighted, you do want it to be copyrighted because you don't want other people to be able to steal it from you, then you really should use humans to create it. Now, other things that you would never go to court for defending the copyright of that, then it's more debatable. Right? Like, why would anyone ever need to go to court to defend the copyright of a needs assessment? Like, I don't see the point in there.
No.
Two people, like, if two people two different companies submit the same needs assessment, they're not going to get funded. Right?
That's right.
So there's no point in copying someone else's needs assessment. And also, like, a year from now, my needs assessment is no longer valid. So, like some things that we produce do not need copyright, at least that I can think of. Someone else might come and tell me exactly why I'm wrong, but strategically it doesn't feel to me like a needs assessment needs copyright, but your logo does need copyright.
Yeah, I agree. It's funny, it's making me rethink. I have a clause in my contract that I use with clients that is meant to clarify about copyright in as a tool to ensure payment, where I say client, I forget my exact wording, but client gets the copyright of the material once payment is made in full. And I have that in there at the recommendation of some other folks in AMWA so that if a client doesn't pay, I can go to them and say, well, if you use the content that I produced without paying, then that's copyright infringement. But I don't know. Do I need to rethink that clause at this point? How fast is this going to change? Where do you see this going in the future?
Yeah. So yeah, I don't know. We may need to, instead of saying copyright, ownership of the product. I don't know. Like, yeah, it is tricky. Maybe that will no longer protect us in the future. And you had a client that specifically raised questions about copyright in image generation, right? What was that?
Yeah, it wasn't the client, it was an educational partner. So a patient advocacy group that was partnering with my client on a CME activity. And we had generated some images for that using AI. And the educational partner specifically said that they don't use AI generated images. I don't know the reason for that. It certainly could have something to do with copyright. Or perhaps, as you and I rail against often, they have one of those company policies that just says, oh, no AI. AI is so scary, without actually giving people parameters about what to use it for. So I don't know what the circumstances were, but we did ultimately have to remove those images from the slide deck.
Okay. Yeah. So yeah, that is something to consider is like some companies, some people still don't want any AI generated
Yeah.
content, whatever type of content in their products.
Yeah.
I think this has been a great discussion.
Yeah, it
Like,
has. Glad we talked
yeah,
about this. And I think we'll have multiple discussions about this in the future, probably, right? Because this is
yeah.
evolving. AI is only going to become, a tool that we use more and more often. So I kind of see this evolving over time, and it's already hard to keep up with, but we'll try and keep up with it so we can keep everyone else updated, right?
Yes, yes. And hopefully we'll hear more from lawyers and the court cases move along and we get some clarity also from the courts, you know?
Yeah, yeah,
Yeah.
definitely. We'll talk about this
Mhm.
more as new issues arise.
Yeah. All right. Thank you. And I'll see you later.
See you next time.
Bye.